Welcome to the Music Rights and Money for Teens presentation. Again, my name is Dave Ogan. I'm the head of third-party partnerships at the MLC, the Mechanical Licensing Collective. I want to thank our collaborator, Save the Music Foundation, on our Junior Music Rights Week. This is just the first of our week. We have another webinar coming up on Thursday, so make sure to check out our social media to see what that information is and tune in then. So what we're going to cover today, it's quite a bit, starting with what is copyright. Then we're going to talk about how does copyright apply to the music industry. I'm going to cover what rights do music copyright owners have. And we're going to dive into what are digital music royalties. So throughout the presentation, if you have questions, again, please use the Q&A box by clicking on the Q&A icon and drop those questions. I'm going to have a Q&A section at the end, and I'll be able to answer those questions for you. So let's dive right into it. So what is copyright? Copyright is a form of legal protection for original works of authorship that are fixed in a tangible medium of expression. I know that sounds like a lot. So let's unpack this into what I call the building blocks of copyright. So when you think about copyright, you have to ask yourself these questions that help you understand copyright and ultimately determines if copyright protection is eligible for a given piece of content. So what is the work? Is the work an original creation of the mind? And what that means is, did you come up with the idea? Did you also create, whatever the work may be? Or are you copying someone else's work, right? So the very beginning of copyright is that the work needs to be an original work, which is why you need to ask yourself, is this work an original creation of the mind? Then it needs to be a tangible medium. So has the work been fixed in a tangible medium of expression? So not only does it need to be original, it needs to be fixed in a tangible medium of expression. And I'm going to show some examples of that later in the presentation. The good news is, once your original work of authorship has been fixed in a tangible medium, it earns copyright protection. So the work earns copyright protection the moment it's created and fixed in a tangible form. So right now on this call or this presentation, if I decide to come up with some creative idea and then express that idea in a tangible form, that will earn copyright protection as long as it is a completely original idea. The next consideration, the building blocks of copyright, is to ask, is the copyright owner the author or a third party? And this determines the duration of how long the copyright protection will endure. So if the copyright owner is the author, meaning me, if I create a piece of art today that I wanted to copyright, that duration is protection is the life of the creator plus 70 years. If the work is a work made for hire, for example, if someone hired you to or commissioned you to create a piece of art that they own the copyright for, the duration of protection is 95 years after first publication, or 120 years, or whichever first expires. Next is the bundle of rights. Copyright protection grants a copyright owner a bundle of exclusive rights. This is what having copyright protection awards you, basically. You have the bundle of exclusive rights to control the use of the work, including the right to reproduce or make copies of the work, the right to distribute the work, the right to prepare derivative works based on the original work, the right to publicly perform the work, and the right to publicly display the work. Again, when you think about copyright, the term copy, like to duplicate something, and the right, the right to do that, the right to copy something is copyright, the original copyright. So these are the rights that a copyright owner has when they have protection, copyright protection over their work. And then lastly, once all these building blocks have been stacked, the copyright owner can exploit, which means to sell or lease or lend or make use of the work themselves or grant permission to others to exploit their work. So I know we just kind of dived in there because there's a lot to cover, but this is the building blocks of copyright protection, starting with knowing that the work is an original creation of the mind. When all the building blocks of copyright protection exists, a copyright owner can register his or her copyrighted work with the United States Copyright Office to unlock additional benefits of copyright registration. So the first thing is to make sure that the copyright building blocks are all in place. Then you can register the copyright and submit a copy of the work. The application is reviewed and approved and filed. Then the copyright ownership becomes public record in the United States Copyright Office database. And then you receive what's called a certificate of registration. So as a copyright owner, you have the option of registering your copyrighted work so that you have additional benefits. The additional benefits include a public record of the existence and ownership of the copyrighted work so that the public can know who is the owner of a particular copyrighted work, whether it's a book or obviously a piece of music. We're talking about music for the rest of the presentation, but there's different types of works that can be protected by copyright. And then the ability to sue for copyright infringement. So if you register your copyright, then you're able to sue someone for copyright infringement. If it's not registered, then you're not able to sue someone for copyright infringement. Moving on, how does copyright apply to the music industry? So copyright protection of eligible works within the music industry provides copyright owners what's called a limited monopoly over the exploitation of the copyrighted work in accordance with copyright laws. This is also known as music copyright law. There are two types of works in the music industry that are eligible for copyright protection. There are musical works, which includes lyrics and the melody. This is also referred to as songs or compositions. And then there are phonorecords, which are the media on which sounds are captured, recorded. So CDs, cassettes, vinyl, and digital audio files like MP3s or WAV files. This is also referred to as sound recordings or records or masters. So these are the two types of works in the music industry that are eligible for copyright protection: musical works or songs or compositions, and phonorecords or sound recordings or masters. And I just want to be clear here that musical works could be a melody with no lyrics, a composition with no lyrics as well, such as an instrumental. The copyright symbols in the music industry is this C in a circle, capital C in a circle, which is a symbol to represent the copyright in the musical work. And then there's a P in a circle, which is a symbol to represent the copyright in the phonorecord. You would see this on services like whether you use a service like Spotify or Apple, and you go in and look at the copyright information for a particular song. There would be a C in a circle for the copyright in the musical work, and then there would be a P in a circle for the copyright in the sound recording or the phonorecord. You'll also see that sometimes on YouTube Music, where the copyright owners want to put their symbol and their label basically on that work. So eligible works in the music industry must meet the same building blocks of copyright as any other work that's eligible for copyright protection. So you have to ask yourselves, is this musical work an original creation of the mind? For example, if I sat here and started writing down the lyrics to one of my favorite songs, and then I go and record it, that's not an original creation of the mind. So that would not be, that what I record would not be copyrightable. The second is, has this work been fixed in a tangible medium of expression? Now, if I sat here and if I hummed a melody and we're able to get a couple of guys to call in and we all work together to hum a melody and come up with a new melody, unless we recorded that melody in a tangible medium, which is like an audio file, that melody would not have copyright protection because it would not be affixed in a tangible medium of expression. Again, once we've done those two things, we've verified that the work is an original creation of the mind and not a copy of someone else's work. And it has been fixed in a tangible medium. We haven't just, performed it without recording or capturing it in some way, whether we handwrite the melody on sheet music, or if we record it with my iPhone. That's a way to create a tangible medium. Then the work earns copyright protection once we meet those two basic requirements. Then the next thing we have to ask ourselves, well, is the copyright owner the author or third party? That would tell us how long, what the duration is of the copyright protection. So if I create the piece of music, a song with lyrics and melody, the duration would be my life plus 70 years. But if I was hired by someone, let's say to create a custom song for a wedding, and that the folks who hired me wanted to own the copyright, then that duration would be a different duration, because that's simply how the law is set up. The work made for, it would be called what's called a work made for hire, and that work will have a different duration of 90 years from the creation, from the distribution or publication, or 120 years from the creation of the song. Then we ask ourselves, does this song infringe on anyone else's bundle of rights? So for example, if I created a song and I used a little piece of someone else's song, am I infringing on someone's rights? If so, that collapses this pyramid, this kind of building blocks of copyright, because now I don't have I'm not eligible for a bundle of rights because I'm infringing on someone else's bundle of rights. And lastly, the copyright owners can exploit the works themselves or grant permission to others to exploit the work. So once I've created this song and I've met all of the requirements of the building blocks of copyright, I can then sell this song, I can distribute this song, I can post it up on my YouTube channel, I can post it on I can upload it to my Instagram, I can do whatever I want to do with it, or I can give that song to a third party to exploit it for me, like a record label, for example, or a music publisher. So next up, what rights do music copyright owners have? So a music copyright owner has the right to grant a person or an entity any of the rights included in the copyright owner's bundle of rights. I know I said the word right many, many times, but again, we're going to break this down. So again, me, the copyright owner, I have the right to grant to you, someone on the in our presentation, any of the rights that I have in my bundle of rights. So let's dive into that bundle of rights. So bundle of rights, for example, we have the right to reproduce or copy. So Mariah Carey came out with a song called Emotions in 1991, and then Ariana Grande made a cover song or a copy of Emotions in 2012. This is the right to reproduce. Mariah Carey had the original work and had to, Ariana Grande is doing a copy, which is a cover. So the right to reproduce or a copy is a cover. The right to distribute is the right to make the work available to the public. So that can be done, for example, in physical distribution, such as distributing CDs or vinyl or cassettes, or even thumb drives of audio files of music, or the right to distribute via digital distribution to some of the major digital services that many of us use already. So the right to distribute, again, is one of the bundle of rights. The right to prepare derivative works. So this work by Farruko was an original, and then there was a remix, and this is called a derivative work. The right to create new or alternate works based on the original work, such as modified versions, remixes, arrangements, and adaptations, is a remix. So A remix is one example of a derivative work, which means if I go and find a track that I like, especially a lot of producers and DJs do this, and make my own edit of it or remix it and put that out, you actually need permission from the copyright owner. Again, that's an exclusive right of the copyright owner of the original. The remix is a derivative work of the original. Another example of a derivative work is sampling. So there's an original work and there's a new work, but it uses a sample of the original work. That's a derivative work. In this case, this is Dua Lipa, who sampled My Woman by Lou Stone, and in her Love Again song. So the Love Again song sampled another song, which makes the Love Again song a derivative work. It's not, however, a cover song because it's not a copy of the original work, right? So a copy, which is the right to reproduce or right to copy, is a different right from the right to prepare derivative works. Then there's the right to public performance. The right to perform the work publicly or to cause performances of the work. One example is broadcast, music performed over radio, television, and in business establishments. The right to publicly perform. Another example is concerts. So the right to perform a song at a live concert, either with a live act like a band or artist, or with a DJ. There's a right to public performance that the copyright owner has. Right to public performance in business establishments. So supermarkets, retail stores, sporting events, restaurants, coffee shops, all these different types of business establishments must have the permission from the copyright owner to publicly perform the musical work. This is the right to publicly perform. The right to public display is the right to publicly display the work or copies of the work publicly. So for example, first a composer affixes a melody in sheet music, then copies of the sheet music is displayed in a music store or online on a sheet music web store. So displaying an actual copy of the work is called the right to public display. So just to recap, these rights, the right to reproduce or copy, the right to distribute, the right to prepare derivative works, the right to publicly perform, and the right to publicly display are all parts of the rights that copyright owners have, and they're a bundle of rights. So what rights do music copyright owners have? Well, music copyright owners generally grant rights to music users in the form of a license. So if I want to, let's say, for example, I'm going to go back here. So in order for Tiesto to create the remix of Farruko's song, there has to be a grant of rights, right? This right to prepare derivative works, because we know that the right to create new or alternate works based on the original work, such as modified versions, remixes, arrangements, and adaptations, is the right, is the derivative work right. So Tiesto has to receive permission from the original copyright owner in order to create this remix. I'm skipping ahead. And all of these examples, in order to use the music in the way that I've described in these examples, that right that's in this box here has to be granted to the user. So music copyright owners generally grant rights to music users in the form of what's called a license. So one example of a license is the mechanical license. And a mechanical license grants the music user, or a licensee, we call them licensees, the right to reproduce and distribute a musical work. So you can see here in this little chart, here are the grants of rights that are included in a mechanical license. Again, a mechanical license is simply the document for granting particular rights. In this case, for a mechanical license, we're granting the reproduction right and the distribution right. We're not granting the derivative works, derivative rights, or public performance rights, or public display rights. So again, different rights have different licenses. For this example, we're talking about a mechanical license. So if I'm an artist and I want to release a cover song, then I need to get permission. A mechanical license is required to reproduce and distribute musical works in physical phonorecords, again, CDs, vinyl, cassettes, to reproduce and distribute musical works in digital phonorecords, like MP3s and WAV files, to create a ringtone version of a song, and to record and release a cover song. So these are all uses of mechanical license. So for cover songs, in the United States, digital music services such as Spotify, Apple Music, Amazon Music, and Pandora secure licenses that enable cover songs to be distributed on their platforms. This means that the artist who recorded the cover song does not have to secure a mechanical license for the digital distribution of the cover song. However, she would still need to secure a mechanical license for the physical distribution. So this artist, let's say, wants to cover a song from her favorite artist. She can record that song and use a distributor to upload that to a digital service without having to directly secure a mechanical license in the United States. But if she wanted to also distribute that song via physical, she would need to secure a mechanical license. So what are digital music royalties? Well, digital music royalties are payments derived from the digital use, access, performance, or sale of music. So we're going to talk about royalties under each of the musical works and under phonorecords or sound recordings that I talked about earlier. So under musical works, for the public performance right, again, that's one of the rights. There are royalties that are earned on, like I said before, on digital music services, on social media platforms, on music apps, on television, and so forth. Those royalties for musical works for the public performance right flows through organizations in the United States called ASCAP, BMI, CSEC, and GMR, which are performing rights organizations. And then those royalties flow down to songwriters and publishers. Then I mentioned the reproduction and distribution rights. Again, the reproduction and distribution right together is granted in what's called a mechanical license. Mechanical license generate mechanical royalties, and those royalties flow down through the Mechanical Licensing Collective, which is the organization I work for that's presenting this presentation. And those mechanical royalties flow down to songwriters and publishers. And then there's licenses that are directly acquired from the digital service and the publishers, and that flows down through what's called a voluntary license. On the sound recording side, which goes back to the phonorecords, we have the reproduction and distribution rights, which those royalties are for the sound recording. And that flows down through distributors and aggregators. Distributors are the services that you use to upload your music, and that flows to record labels and self-released artists. And then lastly, there are what's called digital performance rights for sound recordings, and those royalties flow to Sound Exchange. So these are organizations that are set up to license these different rights that we talked about earlier on behalf of copyright owners to receive royalties and then to make payments to the copyright owners. So songwriters, artists, and what's called labels and publishers, we're not going to dive too much into on this presentation. So now I have a little, let me just get to the next page. I have a little video I want to show you about songwriters and the MLC, the Mechanical Licensing Collective. Some of you may be artists who've already uploaded your music to digital services in the United States. We're an organization that is responsible for paying those royalties to songwriters. So I'm going to play this video.
You're a music creator and want to start making money off your music. So you sign up for a music distribution service that uploads your songs to the top platforms. Now, Your songs are streamed by thousands of listeners every month across the United States. But you might not know that with every stream, you earn separate royalties as an artist and a songwriter. Although you get paid artist royalties by your distributor, many distributors do not collect and pay songwriter royalties. Your songwriter royalties are paid to music rights organizations. Performance royalties are paid to performing rights organizations. In the US, some of those are ASCAP, BMI, GMR, and CSAC. And digital mechanical royalties are paid to the Mechanical Licensing Collective, or the MLC. If you want to collect all of your US mechanical streaming money from your song, you should join the MLC. It's free to join and pays out 100% of the mechanical royalties that it collects on your behalf. And you will receive royalty payments monthly. So what are you waiting for? Join the MLC today and get paid.
All right.
You're a music creator.
So I hope that our little explainer video was able to help break down the fact that there are two types of royalties that are paid out, again, on the songwriter side, which are related to the musical work, and then the artist side, which is related to the phono record or sound recording. We as an organization collect royalties on behalf of musical work copyright owners, and we pay directly 100% of those royalties. So I'm going to open up to Q&A. I know I moved through the presentation a little fast, so I will be able to go back and hop back into slides and dive a little deeper based on questions as well. So if you have any questions, please use the Q&A, the chat feature, and I'll be able to provide answers to those questions. So I see a couple questions have come in already. This question is from Case from LinkedIn. Why is the rate and protections for songwriters and composers still not public knowledge? So I think your question is regards to, when you say rate, I think you mean royalty rates. So the royalty rates is public knowledge. It's dependent on the type of use, the royalty rate is different, but the royalty rates are set by what's called the Copyright Royalty Board. It is public information, but it may not be widely known information in the sense that it's not hidden behind anything. You can, if you're aware of the Copyright Royalty Board and how rates are set, this particular webinar is not about how rates are set, but in regards to mechanical royalties, there's a certain way that rates are set, and the same thing for other types of royalties. There's different processes, but unfortunately, this conversation is not in regards to how rates are determined. This is more general about the copyright and what copyright is and the fact that royalties exist. The second question from Case was, how can the MLC help me create jobs out of 33 million Spotify streams? Well, the MLC's responsibility to songwriters is to pay you 100% of the royalties that we collect on your behalf from digital services that are using the blanket mechanical license in the United States. And any songwriter can sign up for free to that. If you're eligible to join, you have to have your you need to own your copyrights, and you need to administer your copyrights. And if you are eligible, then you're able to join. And just like we show in the explainer video, you collect checks. You get paid on a monthly basis, not checks. We'll do direct deposits, hopefully. Do a monthly basis for the royalties that you earn. So if you're earning royalties if you're earning streams on a monthly basis, then you'll be generating royalties on a monthly basis, and you're getting paid through the MLC. Okay, the next question is from Dina on LinkedIn. What if you own the master 100% and split the musical works song 50-50? That's a great question. We actually just did a webinar on split sheets and splits not too long ago, actually just last week. So, we can, I think that may be actually on our website. You should check out our resources section, our webinars, or on our YouTube channel. But depending on your splits, if you own it 50-50, then you would collect your 50% share of royalties for your song. So that's pretty much how that works. If you own the master, well, the master royalties, and I'm gonna go back because remember I showed that the royalties flow through different organizations. On the left side here, for musical works, you stated, Dina, that you own 50-50 on the musical works side. So when those royalties flow down through one of the PROs, they will pay out based on the splits that you've registered your song with. So you have to register your song with the PRO and those splits, and they'll pay out based on that. Same thing with the MLC. You have to register your songs with us and the collection share. So if you're collecting 50%, then we'll pay out 50% to you. On the sound recording side, you say you own 100%. So when it comes to the sound recordings or phono records, those royalties flow to the rights holder. So if you own 100% of that, then you will get paid 100% of those royalties. Sound exchange is for digital performance. So you would register your recordings with Sound Exchange and your ownership collection shares, and they will pay you out. All right, we have quite a few questions coming in, so I'm good, happy to see that. Okay, Carrie asks, artist is paid by BMI and publisher is paid by the MLC. Okay, that's a great question. And sorry if it went a little fast. That video is available on our website as well as our Vimeo. And I believe it has probably been posted in our chat. So the link to the explainer video, which you can watch again. But back to this slide here, under musical works, which are the lyrics and the music. If you recall, let me just kind of hop around again. I said I'm going to hop around as I slowly answer these questions. Excuse me. So I want to go back and to where I broke down the musical works. So as a reminder, the musical work is the lyrics and the melody. Generally, that's owned by the songwriters or the composers, as well as their publisher if you have a publisher, but we're not really diving into publisher here. So you have the musical works. In this case, if you have a performing rights organization membership, such as BMI or ASCAP or CSAC, then your performance royalties will flow through them. If you have, if you own the copyright, then you can join the MLC as long as you're administering it directly. If you have a third party administering your copyright, then you will not be able to join the MLC. That eligibility is going to be on a case-by-case basis. Again, I want to dive into here just to showcase this again. But you see that there's, under musical works, there's two royalties here. We have the performance royalty, which is related to the public performance right. And we have the mechanical royalties, which is related to the reproduction and distribution right or the mechanical license. So your performance royalties are paid through ASCAP, BMI, and CSAC, and GMR, which are performing rights organizations. Your mechanical royalties will be either paid through the MLC. This is for blanket royalties. This is for digital service providers that are operating under the new audio blanket license. And then there are voluntary licenses, which are direct licenses between services and rights holders or their agents. And then those royalties, those mechanical royalties flow through those voluntary license. The MLC, we collect mechanical royalties from digital music services like Spotify, Apple, and Apple Music for interactive streams because they're operating in the United States under the blanket mechanical license. So therefore, the royalties for blanket mechanical license flows through the MLC. All right, next question. This is from Jen. If I have a 20% share in public performance, but master not included, does that need to be added? So if you are the copyright owner in the sound recording or the phono record, again, those royalties are separate from the royalties that are under the musical work. You may not be the copyright owner in both, or you may be the copyright owner in both. So if you are the copyright owner in both the sound recording and musical works, then you want to make sure that you're collecting all the royalties associated with those particular assets. So musical work is one asset, and the sound recording is another asset. So if you own the master, then you're going to have to make sure that you're collecting as well for that. Natasha asks, do you need a certain amount of streams or on platforms to earn royalties? So the way that royalties are calculated is a formula based on the overall number of streams and then your percentage of streams. So if you earn streams, you technically earn royalties. It may not be a lot until you hit a certain a level of streams. Every platform is a little different because it's based on their revenue as well. But again, I'm not really diving into the rates because this particular webinar is not about individual rates that are being paid, but it is a formula and it takes into account the overall number of streams and your particular streams. And I'm talking about mechanical royalties and particularly for the MLC. In regards to other types of royalties, there's royalties related to music used on social media. There's royalties related to music used on various type of fitness apps and game apps. Those deals are a little different, but every way that music is used, royalties are calculated a little bit different. Marcus asks, what's the difference between the MLC and Song Trust? Do we need both in addition to a PRO? Well, the MLC, we are a music rights organization. We are designated by the United States Copyright Office to administer this new blanket license called the Digital Audio Mechanical License. This license stems from an update to the US Copyright Act called the Music Modernization Act of 2018. That law established a new license, which is the Digital Audio Mechanical Blanket License, and we administer that license. We pay rights holders and their or their agents. So Song Trust is a one of many publishing administrators. Song Trust is a member of the MLC and generally represents their writers at the MLC in terms of collecting royalties on behalf of their writers. So if you are with Song Trust, then you can contact Song Trust and talk to Song Trust in regards to their relationship with MLC. I know that Song Trust have put out a number of webinars and a number of emails regarding Song Trust. I can't speak on behalf of Song Trust, but I have personally been on a Song Trust webinar to help talk about MLC to Song Trust songwriters. Okay, next question from Dina. How do we get mechanical license for a song? Okay, so that's a great question. There's, depending on how, what you're doing with the song, there's different ways to get mechanical license. If you're simply doing a cover of a song, I'm going to kind of go back to an example. Okay, so if you're simply doing a cover of the song, as we see here with the Mariah Carey and Ariana Grande, and your cover is going to be uploaded digitally to digital services in the United States, then you don't need to get a direct license because the services are using, are operating under mechanical license, the blanket mechanical license. Now, if you're going to release that physically in a CD format or vinyl or something, then yes, you need to get permission via, you need to get a license for that. Now, there's different ways of doing that. I can't go into that process because at the MLC, we do not issue mechanical licenses for physical. We only handle the digital license administration. Second question from Dina is, what does MLC pay out? Again, we pay out digital mechanical royalties. So when your song is streamed on a digital service that operates under the audio mechanical license, the blanket license, then you get paid those mechanical royalties. which is different from the public performance royalties. I kind of want to go back and just highlight again these bundle of rights, right? So I want to remind that these bundle of rights have different licenses associated with it. So here, the right to reproduce or to copy is basically, one example is a cover song, but there's the right to distribute, for example, is to distribute to a digital service. So when you combine the right to copy or reproduce and combine that with the right to distribute, those two rights together make up what's called the mechanical license, right? So for example, the right to make a cover song is the right to reproduce, but the right to then distribute that cover song to a digital service is the right to distribute. So you must have both rights, the right to reproduce and the right to distribute, in order to properly do that. So together, those two rights are granted in a license referred to as a mechanical license. So again, a mechanical license includes the right to reproduce and the right to distribute. Now, if you're only doing this digital in the United States, you don't need to go out and get an actual cover song license because the services are operating under the blanket mechanical license. So you're pretty safe there. However, if you're going to distribute via physical, again, that goes back to go back up here. Right to distribute includes physical and digital. The digital method is the license is a blanket mechanical license. The services have to obtain those licenses. That covers the grant of rights for reproduction and distribution. But physical is not covered because that's something you'd be doing on your own. So you need to get your own license to physically reproduce. All right, I'm going to hop over to another question. Carrie asked, I am looking to collaborate with a person from another country. Does this person need to be a member of the MLC, even if song is distributed worldwide? So I'm going to go back to the slide with the breakdown of digital royalties. As you can see here, the royalties are flowing through different organizations, right? So these performance royalties flow through performing rights organizations. These mechanical royalties flow through these organizations and so forth. Now, each country have their own diagram. This diagram is for the United States. So if you are a songwriter and you're a member of a United States organization, then this is where you will receive your royalties. But if you're if the person is a member of an organization in their territory, then they'll receive their royalties from their organization. So for example, if you're collaborating with the artist in the UK and you're here in the US, then the UK have their own equivalent of these organizations, PPL, PR, PRC, I'm sorry, PRS. So there's PRS for music, there's PPL, and there's MCPS. Those organizations are doing the same thing across their own diagram of digital music. If your collaborator is in that country and a member of those organizations, then he or she will receive their royalties from those organizations. That being said, anyone can join the MLC as long as you're eligible to join the MLC. Your country of location or residence is not an issue per se. So if you are in the UK and you're not a member of your local PRO, just what we call collective management organization, or CMO, if you're not a member of your local CMO, then you will collect. You may be eligible to join the MLC and directly collect your royalties for the US performance or the US streams, which flows through the MLC. So it really just depends on your collaborator, whether they're a member of their local society or not. This question is from Mary on LinkedIn. I signed up for ASCAP, but no activity on song wrote. I co-wrote song with another seasoned writer. How come no activity? Well, unfortunately, I can't answer anything for ASCAP. You're gonna have to reach out to their songwriter relations to answer questions in regards to ASCAP. We have a question from David. Who pays number 3 from who? David, please clarify and maybe provide more information? I'm not really sure what your question is there. Who pays number 3 from who? Okay, I think you mean, okay. So you mean the third, okay, yes. So on the sound recording side, you talk about reproduction and distribution rights related to the sound recording. So those are royalties, for example, in the video that we watched. We have some time, so I'm gonna quickly replay that video, and then I'm gonna come back to your question, David, because I think it may be helpful to play this video once again.
And want to start making money off your You're a music creator and want to start making money off your music. So you sign up for a music distribution service that uploads your songs to the top platforms. Now, your songs are streamed by thousands of listeners every month across the United States. But you might not know that with every stream, you earn separate royalties as an artist and a songwriter. Although you get paid artist royalties by your distributor, many distributors do not collect and pay songwriter royalties. Your songwriter royalties are paid to music rights organizations. Performance royalties are paid to performing rights organizations. In the US, some of those are ASCAP, BMI, GMR, and CSAC. And digital mechanical royalties are paid to the Mechanical Licensing Collective, or the MLC. If you want to collect all of your US mechanical streaming money from your song, you should join the MLC. It's free to join and pays out 100% of the mechanical royalties that it collects on your behalf. And you will receive royalty payments monthly. So what are you waiting for? Join the MLC today and get paid.
All right, so coming back over to, now did I help, David? I believe so. Okay, so just as the video showed, there's royalties for songwriters and there's royalties for artists, and that's really related to the high-level copyright here, the musical work which songwriters create, or composers or lyricists. You create musical work, and there's royalties for you, and then there's the artists who are the performers on the sound recording. Now those royalties for the reproduction distribution right for sound recordings will flow through the distributor. You upload your music through a distributor, they receive the royalties back from digital services and pay the record labels and artists associated with those recordings. The songs or musical works are paid through PROs and mechanical organizations here. We have another question coming from Raymond on LinkedIn Live. I'm on Spotify. Does that mean I'm already with the MLC? No. So being on Spotify, meaning you distributed your music to Spotify, does not mean that you're on the MLC. You would need to come to the MLC and actually join the MLC. So you can go to our website. We actually have support available Monday through Friday, 8 a.m. to 8 p.m. I'll just make sure I show this really quick. So we do have support available Monday through Friday, 8 a.m. to 8 p.m. You can also go to our website, mlc.com, and click on the Connect to Collect button, where you can begin the process of becoming a member. It's free to join, and you receive 100% of your royalties on a monthly basis if you're earning royalties on a monthly basis. Question came in from Connor. For beats downloaded online for student learning, what will be the recommended licensing process? I don't want to buy every license to every song until they start gaining traction. We're making original lyrics, but finding beats. Well, everything I went over is in regards to the proper way of participating as a copyright owner or a music user. There are some sites that have their own models that may have already dealt with copyright owners and created a service to be able to provide this stuff. But I'm not sure exactly what you're talking about in terms of what specific website you're talking about, or nor do I have information on that website. So I can't really speak to the specifics of downloading beats online, because I don't know, if the website has already secured rights on behalf of its users, or as a user, if the copyright owner has already provided some kind of permissions In general, however, as again, all of these things have a grant of rights, and to use music in any of these different ways that I've shown as an example generally requires grants of rights. What I will add is that the grant of right does not always have to be a direct grant of right. It really depends on the service you're using. Like I explained, when it comes to cover songs, where in the United States, digital services are using digital services that are operating under our new blanket mechanical license have already received the grants of rights for cover songs. So in this case, an artist doing a cover song doesn't have to go out and get a cover song license because the service has already secured that. That's not the same thing as downloading an instrumental from a website and then recording on it, because when you do that, you're in the right to reproduce or copy, right? So if you're going to download someone's instrumental, you're going to have permission to create a derivative work, right? Because now you're creating a new work which embodies their work, and that means you have to get permission for that. Okay, I'm going to take another answer. This comes in from Carrie. I know this is about the MLC, but what does the Sound Exchange pay for? Digital also, is it similar to the MLC? That's a good question. I'm going to go back to our royalty slide. So Sound Exchange pays for digital performance royalties. I'm sorry, I'm getting all these back up here. Okay, so Sound Exchange, as you can see here, pays for digital performance royalties. Now, on the left side, under musical works, we see that there's performance royalties. And I showed examples of what performance royalties were, such as live performances, DJ performances, business establishments. Those are all performance royalties. Digital performance royalties in regards to sound recordings is royalties from internet radio, satellite radio, cable radio, such as Sirius XM, and other types of internet radio services, like iHeartRadio, for example, cable, cable music channels, as well, like Music Choice, for example, and internet radio like Pandora, for example. So, those are, they pay out for the public performance for the musical work, and they also have to pay out for the digital public performance for the sound recording. Again, these bundles of rights are separate, right? The bundle of rights for the musical work and the bundle of rights for sound recordings are separate. Sound recordings do not have a public performance right, but they do have a digital performance right. So these are the rights that if you own a sound recording, you'd have to work with the organization that signs up for the organization that collects those royalties. So in this case, you join Sound Exchange. Another question came in from Mary on LinkedIn Live. Should I have a split sheet when working with a producer, songwriter before work is done? So we do have another webinar on split sheets. I highly recommend that you check out, which I did. I gave that webinar about a week ago, and we break down splits and split sheets and different types of splits. But a split sheet is a document that you use to capture the ownership information and the various shares of a song when you collaborate. So the purpose of a split sheet is for those who collaborate with one or more other creators. So basically, you have to identify what percentage of the song do you own. So a split sheet is used for that purpose. So generally speaking, if you're collaborating and you intend to put the music out commercially, meaning on a major service like a major DSP, then yes, you're going to have a split sheet, because you need to come to an agreement on how that song ownership is split. And then you have to register those splits with the various organizations, so that when the organizations collect royalties on behalf of that musical work, the organization can pay out the royalties to the individuals properly. All right, so we have 2 minutes left. I'm going to leave 1 more minute for any last questions. And then I'm going to, well, while those questions may be coming in, I'm going to remind you that we do have support available at the MLC. The MLC Mechanical Licensing Collective represents songwriters and publishers. You can become a member. Again, it's 100% free to join. It's a monthly payment on the royalty side, and we don't take any percentage out. All this information is obviously important for creators of all ages to understand that the music you create can earn copyright, and copyright entitles you to a bundle of rights that you can use to protect and monetize your music. But it's also important to understand, being on the other side of the usage of copyrighted works, to know that there are copyright owners who have rights that you may be infringing on by using music in a certain way, whether it's in social media or digital and other types of ways. All right, well, thank you very much for tuning in. This recording will be up on our website in our webinars section, or on our Zoom, or on our YouTube later on. So thank you again for everyone for joining.